Fani Willis rages over the cell phone records that have been proffered to the court by Trump's defense. We reviewed those in depth. We learned that even though Nathan Wade said that he was only over at Fani's condo, less than 10 times, turns out it was about 35 times. They were texting each other all hours of the night. There was some Fani booty calls going on. Nathan Wade got the call at 11:30. Fani's like, I need to be indicted right now. He's like, I'm on my way, baby. He gets in the car and they tracked the whole thing. His cell was pinging off the towers on the way over to Fani's condo, and we have some concerns that they lied to us because they said that their relationship didn't start until 2022. They put that in an affidavit to the court. They may have lied about that because many of these phone calls and text messages, thousands of them, were taking place in 2021 before this all started, according to them. And so now we're talking about perjury, and now we're talking about losing your law license and maybe going to jail. And so Fani's very upset about this. She responded, and then Trump responded. And so we're going to see how Trump just obliterates her response. But Fani was very, very upset. All caps, bold, underlined. I think the only thing she forgot was the italics, but that makes it look weird. So here is Fani's response. Very unhappy in Fulton County, Georgia. Fani comes out and responds to Trump's submission of cell records that show these two little lovebirds were colluding with one another in the bedroom a full year before they told us it started. Fani responds. She says, all right, Judge McAfee, here is Fani's objection. They say, here comes now Big Fani Willis, the biggest Fani in Fulton County, and we move this court McAfee to exclude Donald Trump's proposed Exhibit 38. That's the cell records, which has been improperly submitted to this court in violation of the law. They say supplemental Exhibit 38, the reason why this has to go, it contains both telephone records that have not been admitted into evidence and an affidavit and other documents containing this expert's unqualified opinion evidence. And for the reasons set forth, this court must exclude all of this material or at a minimum consider our government rebuttal evidence. They tell us. Now, a lot of this is going to be technical. So in any criminal case, you have expert witnesses. And one of the things that you want to do is make sure that they're actually an expert. And there are standards about this that the courts have articulated for us. And it comes from a case called Daubert, which we'll hear more about. But they're going to try to get that testimony, that affidavit that shows all the cell phone records with the slideshow and the heat map and all the stuff that we described, but we didn't actually see because it was filed to the court exclusively. They say that that is just unreliable. It's not from a real expert. They say Trump and his proposed exhibit was improperly submitted in direct violation of this court's own rules. Now they say while Trump and his exhibit, while it cleverly avoids the use of the term expert, it is clear that Trump's submission is an attempt to have this court improperly receive unqualified expert testimony. And what they're doing is they're citing the court's own rules. They're saying, Your Honor, you said in your standing case management order for criminal cases, you said you got to provide written notice to the opposing party. You got to disclose a summary of the expert testimony. And you got to do it 7 days before any evidentiary hearing that requires that person to come in, right? And so this is what the judge signed, for the prosecution, for the criminal case that is brought by Fani against 19 co-defendants, now 15 remaining, 4 have taken plea deals. So the court's own order goes to that provisions. And they say, sorry, judge, you already, said the rules, like you can't change the rules after the game starts. And so you already said we needed 7 days notice. You already said we needed written notice. You already said we needed a meaningful summary, and we never got any of those things. They say here, Trump's proposed exhibit, it violates your order. Trump provided no written notice to us. Trump provided no summary of their testimony. I mean, he kind of did. It's in their affidavit. Trump provided no information related to the qualifications of him. He did, right? It's in there, but they're saying, well, he should have given us to us before he filed all this. And no notice was provided at least 7 days before the evidentiary hearing, right? They're saying, well, we should have gotten it earlier. Now you could turn around and say, yeah, I mean, you got plenty of notice. It's in the filing. We all read it. Most of America has read it at this point. We know what you two were doing. And, these are all technicalities. And I would say, well, this whole thing is deviation from the standing case management order, which is for the 19 co-defendants, now 15. But they say, look, at the conclusion of a portion of the hearing that was held talking about disqualification, they say Trump stated the following. They said, okay, McAfee, we're in the process, if the court will allow us, to get certain phone records. And we'd like to keep the record open for the introduction, and we'd have them in draft informally and blah, blah, blah. But they say, we'd like to reopen and introduce records and someone to explain what they mean, right? This is Trump's team back during the hearing. And counsel for Roman, this is Ashley Merchant, this was Steve Sadell. Merchant said, as soon as we get a hearing date and the state's response, when the state responded on the 9th and admitted to their relationship but put parameters on the timing, I sent subpoenas out in response to that. The problem though, says Ashley, Delta, AT&T, they aren't fast. And so I wanted to remind the court, waiting for those records to be submitted in camera, behind the bench in the judge's chambers. And actually AT&T emailed me these phone records yesterday morning morning on the way to the court. So they're saying, okay, see, even the defense lawyers, this is Fani's team writing, even the defense attorneys were saying, like at the hearing, they were saying, we have to get these records. They say representations made by the defense team, they make very clear to the court that they issued subpoenas for telephone records that are at issue on or about February 9th, that they had subpoenaed their records at least as early as February 15th, and defense counsel, they always intended to attempt to introduce both the records and an expert witness to explain what they mean. So they're saying they were plotting on us. They were colluding. They know what they were going to do. We're like, yeah, they did. That's why Steve Sadow asked Nathan Wade that question, because he knew he had evidence that he was going to hit him upside the head with. Now, in spite of this, they say Trump made no effort to comply with your own orders, Judge, and Trump provided no written notice to us in advance of this hearing. And so if we don't have notice, you got to exclude it, and provided no summary and provided no information related to his qualifications. And your orders, you already said this, Judge, was specifically intended to prevent this ambush type of legalese with purported expert evidence without allowing us a meaningful opportunity to review any of this and to review the purported report and to obtain our own expert in rebuttal. And so we just got totally blindsided by it. We had no idea. So the court cannot now, says Fani's team, allow Trump to bypass this protective procedure when, in other cases, it has excluded expert evidence for a party's failure to follow the order. Now, all parties coming before this court must be treated equally, which is LOL, isn't it? Treated equally. Fani, give me a break. Should they all get millions of dollars from the taxpayers too and sleep with Fani? No thanks. Indeed, treating like cases alike promotes a system of equal treatment under the law rather than one built on arbitrary discretion, which is literally what this entire case is. And he is citing a case that references Alexander Hamilton, and I'm not happy about that. Keep his name out your mouth. Here is the guy who's writing this. This guy's name is Adam Abate, okay? The same guy who is screaming about sanctions. Yeah, Adam Abate, okay? Same guy who wanted sanctions against Ashley Merchant, now quoting Alexander Hamilton. Give me a break. All right, so he continues in his rant. This is Fani, okay? So I'm gonna show you where Fani comes in. Defendant Trump's supplemental, they also say, was in violation of other rules. They say, first of all, Georgia's rules of evidence say expert testimony has to follow the rules. And we know that in different cases, there was this Daubert case, which was a Supreme Court case from 1993, which tells you how to qualify experts. But they say Trump now seeks to submit another exhibit, which contains this affidavit from this dude called Charles Middlestat that consists of opinions that are based on science and technical and specialized knowledge under the rules. And so if it falls within that, if it's scientific, if it's technical, or if it's specialized, it meets the Daubert standard. And under Georgia law, he's got to be qualified. And they say no applicable exceptions exist under here. He is an expert. And so if he is going to be an expert and proffer this affidavit, then you must consider these things. One, expert's scientific, technical, or other knowledge. The testimony, whether it's based on sufficient facts or data. And this dude, does this all the time. He explained that in his affidavit. So I'd say that's good. Testimonies based on sufficient facts or data. He got a full year of phone records from Nathan Wade. I'd say that's good. If we even needed him as an expert, we're not there yet, but if we did, the testimony is the product of reliable principles and methods. Yeah, Fani Willis and her office used this stuff in their own prosecutions. And the expert, this guy Middlestat, has reliably applied the principles and methods to the facts of the case. I'd say he hits that one too. But they say the party advancing this has to make sure he's admissible. And we haven't done that yet, right? So even if the judge wants to accept this, he's got to go through this process. 4 steps. You got to verify he's the thing. You haven't done that, Judge. Therefore, here, none of the required findings have been made by the court, and no timely or competent evidence that complies with your prior order, you already said it, no takebacks, exist in the record to establish that even one of these factors is met. And Trump has provided no competent evidence whatsoever that would establish that Middlestat is an expert in anything. Fani continues. Now, moreover, the telephone records at issue themselves, so this is all disqualification stuff for the expert, saying this guy's not even trustworthy, get him out of here. But even if you look at the telephone records themselves, which form the basis of his entire expert testimony, they are not properly in evidence anyways. No one has authenticated this, and if you're trying to introduce this as a business record, it says you shall make both records and the declaration available to the adverse party. And so once again, we didn't get enough information. And contemporaneously, providing the certificate and the telephone records after the close of evidence, they say the hearing's already done, is not sufficient to advance notice. Now, the court should not excuse Donald Trump and his failure to comply with the law. It's clear that Trump subpoenaed these records as early as February 9th, and they keep bringing that up to say that he could have told the other side about this and had both the records and the declaration in his possession by the 15th. Rather than telling us about any of this, he never provided notice to us. And now he's attempting to ambush the state with these unauthenticated records only 5 days in advance of the scheduled closing arguments to provide the state an opportunity to rebut this evidence. And again, they are a prosecutor's office. They should have cell experts on call readily. They're probably prosecuting people with similar evidence. So they're like, we're scrambled here. So the court should not now reopen the evidence, right? A lot of this is technical. Disregard its own standing order and allow Trump the opportunity to qualify Middlestat as an expert witness when it's already declined to do so. All parties coming before this court must be treated equally. Now, if the court determines that Trump's inadmissible can be considered, then you must also consider our rebuttal evidence. And I think this is where Fani's coming into play. Yeah, you see it there? She's coming up. Says here, notwithstanding the inadmissibility of Trump's exhibit, pursuant to your own evidentiary ruling, phone records are inadmissible. When the state attempted to impeach Terrence Bradley by concerning circumstances about his departure, the court said you can't introduce extrinsic evidence to impeach him, right? And remember this testimony. Terrence Bradley was up there. He was vouching for Nathan Wade. You know, we're like, wow, this guy's totally lying on the stand. Okay. Anna Cross comes out and is like, didn't you assault your employee and a client? He's like, what? Absolutely got shanked in the back multiple times by Nathan and Anna. And Fani was back there too. And so they tried to bring in that relationship, the assault relationship between Terrence and someone else in as evidence in this case. And that's not what we're talking about here. We're talking about Fani and Nathan. So the judge said, well, under Rule 608, I don't see how this is relevant, and kept all of that out. But now the government is saying, well, if we can't bring in outside material to impeach our witnesses, you can't bring outside material in to impeach your witnesses. But this is very different, right? Because the evidence that is being brought to impeach Nathan Wade is the cell phone records. And that goes to the core of his credibility, which does relate to the issue, which is the Fani-Wade relationship. So this whole point, I think, misses the mark big time. They say here, Trump attempts to do the same thing. He seeks to introduce extrinsic evidence that's contrary to Nathan Wade's testimony for the purpose of impeachment because it's related to the relationship. Now, if the court did not allow the state to impeach Terrence Bradley, who's not a subject to this relationship, it cannot allow Trump to do the same thing. All parties coming before this court must be treated equally. Is that the second time they said that? Oh, they're like broken records. Yeah, again, thanks for that. Thanks for repeating yourself. Now, this is where I'm pretty sure Fani was in the room when they were writing this filing. Look at this. It's about to get heavy in here. So this prosecutor continues, but even if, Judge, in spite of all these evidentiary deficiencies, if this court determines that it can still consider Trump's exhibit, well, the phone records simply don't prove anything relevant anyways. The records do nothing more than demonstrate that Special Prosecutor Nathan Wade and his telephone was located somewhere within a densely populated, multiple-mile radius where various residences, restaurants, bars, nightclubs, and other businesses are located. Then it's about to get spicy. You can see Fani is here. She says, I think this next sentence should be in bold. He says, I think you're right. I'll put it in bold. And then she says, that's not good enough. Underline it. He says, Fani, I'm not sure. That's too much. I think the judge might get mad at us. Underline it. He's all right. Control you. Control you. He underlines it. Fani starts screaming. The records do not prove in any way that the content of the communications between Special Prosecutor Wade and DA Willis are there. They do not prove that Wade was ever at any particular location or address. They do not prove that Wade and Willis were ever in the same place during any of the times listed in the exhibit. And in fact, on multiple relevant dates and times, evidence clearly demonstrates that Willis was elsewhere, including at the Fulton County District Attorney's office. And then they go into psycho caps lock mode. Fani's like, caps lock it now. He's like, all right, I'll do it. Caps lock. And visiting the 3 crime scenes where a mass murder motivated by race and gender bias had taken place. And everybody's just like, oh, period. Oh, he's crying. The guy who's typing, oh, why'd you do this, man? And, you know, there are a bunch of people there. She wanted to increase the font too. She was going to italicize it, but it probably looked weird. She was going to increase the font like probably to, 14, maybe 16. And everybody had to pull her back, okay? People were like pulling Fani off the keyboard. That poor guy. So hopefully he's recovered. So you can see, my friends, I'm only like half joking about this. Like, she's actually yelling in a court filing. I don't think I've ever seen this, all right? Screaming about race and gender bias. Screaming, right, in caps lock. Ah! Like, you're writing in all caps, Fani. You're screaming at the judge. And she's screaming, apparently, because she was investigating a murder focused on race and gender, and now Trump is trying to murder her based on race and gender. Now the DA is getting murdered here, Judge. I'm getting murdered too. And this is wild. Like, I understand, bolding a word or two, but you're not going to see this much more here, my friends. We read a lot of court documents here. A lot. Have you ever seen anyone screaming at the judge? Screaming. And visiting 3 crime scenes. Like, that's what's happening. Remember the scene from her in court where she's grabbing the documents? It's a lie. That's literally what's happening here. She just wrote it. And so it's just very dramatic. So anyways, they say the state submits that Trump's proposed exhibit was not not filed in good faith, but instead it's nothing more than an attempt to garner salacious headlines in the media. The New York Post article and others are patently false, and others are misleading as well. And roughly simultaneous with the filing, counsel for Trump, Sadow, immediately provided unredacted cell phone records, which he admits was a mistake, that contained personally identifying information to the media. And he responded in an email. He said, sorry, I accidentally, gave it out. Trump's proposed exhibit, it includes an attempt to introduce an affidavit, even though Trump insisted the state was disallowed from doing so and compelled Wade to testify. So you made our guy come in and testify, but not their guy come in and testify. We couldn't submit an affidavit, so they can't submit an affidavit. And saying Trump's proposed exhibit also fails to comply with the court's standing order and evidentiary rules, and moreover, the state questions, here we go, whether Trump legally obtained the cell site information in the first place. Like, these are the prosecutors who are now threatening them with crimes almost. How did you get that? Which is generally only obtainable after a finding of probable cause and an issuance of a search warrant. And what we've learned since then is that this is common procedure in Georgia. Defense attorneys get cell phone records all the time. It's just basically a public records request. If you're a lawyer and you're on a case, you can request it. I learned that. And you know how long I've been practicing law in Georgia? 0 years. You know how long this guy has been? I don't know, but he's a prosecutor. And so when we talk here about how incompetent this whole office is, you're watching it on display. We might charge them with the crime because they got a search warrant, got a subpoena. They're allowed to do that, weirdos. For all these reasons, it's clear that Trump's exhibit is inadmissible and it was not filed in good faith. And so it should not be considered by the court. Yeah, that's a one word right there. And for the reasons set forth below, the court must exclude the inadmissible statement and exhibit from Trump. Now, we're not done on this one yet. This is just even more ridiculous. So I want to share with you, remember when they said she was all over the place at these various locations? She was working. She was on other locations at relevant dates and times. She was working, all right, at the DA's office. And so to show us how hard she works, they included some of that material for us to take a look at. Here is the case management order, which is for, the defendants, for the co-defendants, not for Fani, but she says it should apply to me too. She thinks she's on trial. She's not. I mean, she kind of is for disqualification, but none of that necessarily applies to her. Point is, here is the phone records, which were also sent in. So this person certified the phone records and authenticated them. Kiviandria Lang did all of that. Now look at what Fani has given to us. Remember in the affidavit that was submitted by Middlestat, there were 2 different dates and times in there that he investigated. One was, I believe, in September. The other one was in November. One was before the appointment, and both of them were before they alleged their relationship started. So 2 dates were investigated pursuant to the affidavit, and Fani just returned a bunch of redacted emails, okay? We talked on Friday about how flipped they were in their office, how it looked like probably, the place was on fire. Everybody was running around, dogs and cats flying all over the place. It was madness there in Fulton County. And Fani then just printed out a bunch of emails, and she's like, here, just slap that to the back of this stuff. And here's what she sent in. So apparently, here's one filing in Exhibit C. I don't know what this is for, but here's the subject, cases presented, okay? So she says, I was working. I did work. On August 3rd, I was there, and I got an email about cases presented. I sent an email. I sent one to someone, cases presented on August 3rd. Great. Then here's another one. This email is also from Fani on Tuesday. Another correspondence. Big deal. Here's another one. August 23rd. They send in some emails. Look, she's sending emails back and forth. Understood. Like totally irrelevant. Greetings all. Responding to this. Responding to this. Now, some of this might be filed under seal, so we don't know what it is, but she's probably talking about that murder. I was here and I was investigating this, and Fani Willis, and I'm doing all this. Thanks, Fani, for showing us that you actually did some work. Now then, to really confirm that for us, she also gave us her calendar. And I know many of you work your butts off out there. I certainly do here. And when we start our days, we usually have somewhere to be, kind of early in the morning, some obligation, especially on a Monday. Mondays are pretty busy. But this is Fani's calendar from April 12th, 2021. This is before Nathan Wade's appointment. This is before Fani said that they were in a relationship in 2022. And so let's take a look at her grueling schedule, shall we? Here's a day in the life of Fani Willis. It's a Monday. You know how Fani gets. She needs her mornings to herself. So don't bother her. Fani's going to stroll into the office. What time is she going to get there? 11:30. Please don't bother me in the morning. And courts have 8:30 dockets, 10:30 dockets, a lot of activity in there in the morning. But Fani can't be bothered. No meetings before 11:30, all right? Then when she finally gets into the office, she has her first meeting at 11:30, and you know what it is? It's lunch with her boyfriend. Yeah, Nathan Wade. It's a meeting with the anti-corruption team, okay? That's Nathan's team. And it's a meeting with Fani and Nathan. It's a 2-hour lunch in the conference room, all right, with her anti-corruption team, AKA her boyfriend. 2 of the most corrupt people in Fulton County, they have an anti-corruption meeting, right? They call it an anti-corruption meeting. The other name they could have called it was the definitely not sleeping with each other meeting, you know? Oh no, we're gonna meet about why you shouldn't sleep with your employees and your staff. Put that on the calendar. So the corrupt meeting, the most corrupt officials have an anti-corruption meeting for 2 hours, okay? So they have lunch from 11:30 to 1:30. Fani is supposed to be paying attention to this board meeting, but it's a Zoom meeting. So she just calls in, she puts it on, you know, she turns her camera off because she's busy with her boyfriend for these full 2 hours. And, you know, camera off, like, oh, whatever, board meeting. She sits there talking to her boyfriend. Then there's some child abuse prevention thing, half hour. She probably shows up. Thank you. You know, they give her an award, whatever. Yeah, hey, great. And then after that grueling day where she turns off her camera for a board meeting, spends 2 hours with her boyfriend, then that afternoon, guess what's next? Oh, 100-day celebration for Fani Willis. It's like a joke. 100-day celebration for 2 hours from 2 to 4 o'clock. And this, a bunch of people got an invite to this. It was in the courtyard out the Pryor Street courtyard area, beautiful area, near the Assembly Hall. Oh, isn't that beautiful? And it's celebrating 100 days of accomplishments. Wow, what a historic effort this is. And then apparently there was some other meeting in a conference room. I don't know if that was Nathan again, you know, indicting each other. And she blocked something else here for Fani Willis, celebrating Fani. Fani has on her calendar to celebrate Fani. She is the biggest Fani in Fulton County, obviously. So they gave us this date, right? She does nothing. And, you know, maybe she was coming back from a cruise here, which is why she was so tired. She needed to take some morning off. But this is April. This isn't any of the 2 dates that we have any concern about. So she just showed us some random day of her schedule, which is like pathetic. Okay. Most people, this schedule is like a joke, you know, and I used to practice law very, very aggressively. I would be in 4 courts in one day, 8:30 docket, 1 court, 10:30 docket, a 1:30 docket, and a 3:30 docket in multiple locations. Now, you're not going to do that if you're the county attorney, but this is like, I don't know what this is. That's one example. They give us another one. Okay. This one is on April 20th. And again, not one of the 2 dates that was in the affidavit in the first place. So then they have another meeting with whoever that is. I don't know who that is. Is that Nathan Wade? I don't know who that is. So that's a 3-hour meeting. Don't know. Meeting with somebody, probably not Nathan Wade, probably someone else. Here's another meeting with someone else. There's a beginner session for some Odyssey training, whatever that is. And then there's more training. Okay. Which I'm sure Fani's not doing anything of that. So she's sitting here rapping about something with somebody and then sitting in training from 12 to 5. That's your county attorney ruling schedule. Here's May 10th. Oh, she's working on the spa killings, whatever that means, right? So she's sitting around in the mornings, letting other people do a bunch of work. Then she talks to the Zoom meeting victims from 5 to 6 o'clock, right? This day is a little bit more substantive than the other ones, but you know, there's some legal work probably happening here. She's probably having to look at some case files here and then talk to some victims there. Okay. Yeah, that's some heavy work. I get it. But this is the rest of Fani. Okay. And the rest of her filing is just, I do work, you know, and see, she's saying here, can I see you before you push this one to the printer? This is November 17th. Okay. 4:44 p.m. Now we're in the ballpark of the dates we're looking at. And we notice this, look at the size of her signature. Okay. That's a 32-point font, at least, I would say, at least 32-point font. And I have to point out the obvious that when we call her the biggest Fani in Georgia, she confirms it at every opportunity. All right. You know that she's Fani Willis because of her email signatures. It punches you in the face when you get an inbox. I am Fani Willis, baby. Yeah. Signing her signatures on every one of them. Here's another one. Fani Willis. I do actually work, you know. I am working. I told someone to order these books today. Fani Willis. Don't you forget it. All right. Everybody that she talks to, make sure they remember who she is. So, all right. The rest of this is just emails. It's like, you know, I do work. I'm not only indicting my boyfriend. And the rest of this is just articles from all the people who say that she's corrupt as hell. So that is the response. Now, Steve Sadow did confirm that some records actually got out to his error. Steve Sadow says, I inadvertently sent the unredacted cell phone records to Bill Rankin this morning. When I realized the error, I immediately contacted him, told him, do not disclose that to anyone else and do not publish the cell phone numbers or other protected information. Mr. Rankin indicated that he understood and he would not publish the cell phone numbers or the address. It was my mistake alone. So mistakes happen, you know, not something that is intentional, obviously. And my understanding is that those numbers have gotten a bunch of phone calls to them. And I want to always say that, you know, any phone calls to any public officials get looked at with extra scrutiny. Any texts, any phone calls, any messages, they will arrest people and put them in prison for that. So, you know, be extra cautious with any of that information if you've come across it, and they don't play around with that. So that is Fani's response. And you can see it's kind of a ranting screed. She's literally screaming at the court in all caps, underlined and bolded. I don't think she increased the font yet because somebody stopped her for sure, but she might next time. Now, she gets obliterated in the next filing by Trump's response. Donald Trump's defense team responds to Fani Willis, who is trying to get the phone records deleted from the history books because they're so damning to her case. They do not want Exhibit 38 to be admitted as evidence. And Steve Seidel, the person and the team that originally got this data in the first place, are responding. They say, this is President Trump's reply to Fani Willis's attempt to exclude this evidence. They say, all right, Judge McAfee, your affiant Middlestat, the person who created that affidavit that detailed all the records, is not being offered as an expert witness. So neither the court's standing discovery order nor the Daubert standards under the Supreme Court apply. Sorry, Fani and Abate. They say the state protests that the defense, that's us, Trump, is somehow not entitled to present expert testimony regarding the cell site location information, as they allege that the defense, that's us, we failed to comply with this court's standing discovery order. That order mandates prior notice to the opposing party of a party's intention to introduce expert testimony because they claim that the defense has not pre-cleared the evidence through the process of a Daubert hearing. However, Trump's defense says, well, it's a nice theory, but neither of those preconditions apply here because the cell phone information that the defense intends to introduce through the testimony of Middlestat is not being offered through expert testimony, and Middlestat will not be offering any opinion testimony at all. He instead will be summarizing the data that was produced by AT&T in response to a lawfully issued subpoena, as well as factual information that he acquired regarding cell site locations. And there's a footnote here that says, you know, the state is being pretty ridiculous. They put on the final page of their useless motion that Trump obtained the cell phone maybe illegally, the cell phone records, calling it a last-ditch claim. They say that is patently frivolous. These prosecutors should know better. The records were obtained by a valid subpoena issued to AT&T. As the state hopefully knows, hopefully they don't know, defense counsel cannot apply for a search warrant, and a subpoena that they did apply for does not require the probable cause standard to be met in order to be issued. So again, like, these prosecutors are not that competent, and they're correcting them right there. No, we're not allowed to get a search warrant, you know, because we're not prosecutors like you. That's you. But we can get subpoenas, and in Georgia, it's pretty easy for them. There's an exception that allows them to go do this, so they do it. So obvious. Now, Trump's defense continues. They say, first, let's be clear about what's happening here. Middlestat is not an expert, and so he's not going to fall within all those requirements that you articulated before, Abate. They say, first, the 11th Circuit has held that precisely the type of evidence that Middlestat will offer does not require the testimony of an expert. You can go to the 11th Circuit case from 2014 and find it. In Ransford, the government presented a witness from the cell phone service provider who explained how cell towers work and how evidence preserved in the company's computers can show what tower a cell phone was pinging at a certain time. And a police detective also testified how call phones ping off towers. And in that case, the Ransford court explained why the company's witness was permitted to offer testimony. And that testimony was neither expert testimony nor was it opinion testimony about the cell towers and the locations of the phone. Here's what the court said. They said in this case, the prior case, the Dikovitsky, who was the witness, this cell phone witness guy, he explained how cell phone tower records pings from each cell phone number and how he can map the cell phone tower locations for each phone call in numerous exhibits. Now, Hannah, the other side, does not point to any statements of opinion by the expert or the non-expert, and we do not find any in the record. So what was his opinion? If he just comes out and describes how it works, is that an opinion? No, there was no opinion. Hannah does not contend that this testimony was beyond the witness's personal knowledge or that the cell witness should have been treated as an expert. And so we rely on another case where we held that a financial expert's testimony that matched billing records to payroll were factual statements. They were not statements of opinion. So if you have somebody come in and say, well, this is how all this works, what is your conclusion? Well, based on all of this, it's my conclusion that, which, like in the George Floyd case, for example, okay, those were experts who came in and said, I think it was the knee to the neck. Other people said no. They had a conclusion. But if you just brought in somebody to come in and talk about how lungs work and not come to a conclusion, that's a different type of witness. So the testimony did not require expertise because it was a summary of financial records that the witness already reviewed. And it was an explanation of how the summary was calculated. And so, moreover, there was no suggestion that it was inaccurate or prejudicial since there was no opinions. And so the testimony was properly admitted under the rules. Trump's team continues. They say the holding in the Ransford case that is relevant here, it dictates the results in this case. Questions about the interpretation of Georgia evidence code they rely on the 11th Circuit precedents if there's absent any contrary authority from Georgia appellate courts. Go up to the 11th Circuit unless Georgia says differently. There is no contrary authority from any Georgia appellate court that says we can't use this witness how we're intending to use him. And secondly, there is clear authority that cell tower evidence, like Nathan's, linking a particular phone with a particular cell tower at a particular time, that can be established through the cell phone records without any witness testifying. The 11th Circuit in Sanchez said that they approved the use of business records exceptions, so to admit cell phone records and tower records that documented the tower nearest to the cell phone when the phone was by that tower, as well as the number that was called. All of that was allowed. The government, this is why this is so fun, is because normally it's the defense saying, you can't admit that, that's my right to privacy, that's an invasion. The government said, no, that's fine, government can do whatever they want. It's just prosecutors. You're a criminal anyways, whatever. So the government in that case was permitted to later call a detective to testify only as a summary witness regarding what the record showed. Now, Georgia courts, both before and after the new code was enacted in 2013, they've allowed this. They've approved the business record exception to admit evidence to show the location of a cell phone in relation to a tower. Another Georgia case from 2014. A lot of case law here. You notice what we don't see here? Bold, underlined, caps lock screaming. And I don't know if we're going to get that. Maybe, but probably not, because these are sane lawyers. Third, the introduction of computer-generated evidence similar to these cell phone analyses has also been approved without the need for expert testimony. In a recent Fifth Circuit decision, the court held that expert testimony is not required to introduce the information from a cell bright extraction from a cell phone. A trained technician who testifies that he operated the apparatus properly can explain what he did and the results obtained without being able to explain how the cell bright extraction works. Here, Middlestat, for Trump, he used CellHawk instead of CellBright. His testimony will mirror, though, the testimony offered in Georgia courts and courts throughout the country. When one uses a cell phone, either by texting or calling or receiving a call, or by simply having a cell phone on so that it is constantly pinging, a cell tower nearby will receive and record the ping. This evidence simply shows the approximate location of the cell phones based on the nearby cell towers. And so they say, Your Honor, Judge McAfee, our witness, Middlestat, his testimony will be precisely what he described in his affidavit. Most importantly, 2 dates. On September 11th, Wade's phone left the Doralville area and it arrived within the geofence located on the Dogwood address at 10:45 p.m. It's Fani time, booty call. The phone remained there until September 12th at 3:28 in the morning, at which time the phone traveled back directly to Nathan Wade's residence. The phone arrived in East Cobb at 4:05 a.m. and records demonstrate that he sent a text at 4:20 to Miss Willis. I'm home safe, baby. So good to see you. Sleep well. And that's the game. Goes over 10:45, does the old indictment of Fani, and he's back in home at 4:20 in the morning. Good night, sweetie. On November 29th, same thing. Wade's phone was pinging on the East Cobb towers near his residence. November 29th comes in. Fani, she's feeling a little lonely over there. You know, I had a stressful day, not doing anything, celebrating my 100 days. She sends him a phone call. Following a phone call from Miss Willis, more accurately, from Mr. Willis's phone. So is that her father's phone? At 11:32 p.m. And while the call continued, his phone left the East Cobb area just after midnight and arrived within the geofence located at her address, 12:43 in the morning. Fani says, I need some Nathan. He comes over there and the phone remained there until 4:55 a.m. Clearly a Fani call. That's all. He's just going to explain that. That's all. He's not going to offer any opinion. He's not going to testify as an expert. He's only going to be a summary witness explaining exactly what the records show. Now, the prosecution will surely point out that nobody knows what was happening in the house between midnight and 3:28 a.m. Yeah, what was happening in there? Nobody knows what they were doing. They could have been working on legal filings, okay? And nobody knows what happened between midnight and 5 a.m. on November 30th. Now, Middlestat does not claim to know either. He doesn't know. The phone wasn't recording anything, fortunately for us, but it was there. Now, neither does President Trump or any other defendant know in this case. We have no idea what was happening. Only 2 people in this whole wide world know, Nathan and Fani, and they are certainly the ones who should testify and say exactly what was happening on those occasions so nobody in this world will complain about improper speculation or improper efforts to distort the truth or nefarious contacts with the media. Just come out and explain it, Fani and Nathan. What were you working on? What kind of memos were you working on? Having late night talks over a cup of tea? Yeah. All we have heard from Wade and Willis so far has been they did not have a romantic relationship until 2022. Yet it's highly significant meant that the state's response that we just read did not even attempt to challenge the evidence regarding the September 11th and 12th date or the November 29th and 30th dates. Did you notice there was no denial in that at all? They just threw other dates in there, like April. The defendant's business record evidence is admissible, and Middlestat stands ready to testify as reflected in the affidavit. Now, this evidence is admissible because it is extrinsic impeachment evidence that's relevant here. They say they argue that this evidence is improper extrinsic evidence, but this is just simply not right. Yeah, it's true that Rule 608B limits extrinsic evidence, outside evidence, when the primary evidence is nothing other than evidence that is offered to prove a witness's lack of credibility based on some prior bad act, right? It's broad. But this evidence here, this cell phone evidence, it is not being offered for the purpose of showing a prior bad act that impeached Nathan's credibility. There is no prior bad act. Thus, the prohibition on extrinsic evidence has no applicability here. You're citing the wrong rule, government. Instead, the rule that is applied here is this one, which provides in the broadest terms that a party is entitled to offer evidence that contradicts the testimony of a witness, which is exactly what this is. The witness in this case, both Wade and Willis, they testified that their romantic relationship did not begin until March or April of 2022, and that they had never spent the night together prior to the spring of 2022. Two lies. Now, the evidence offered by the defense will refute this testimony, and it's all permissible under the rules. They say, the state's response also fails to factor in that the more extensive data for the two dates, including the cell hawk, those two dates, including the animated map, which details every cell tower hit along the route of travel, it demonstrates that Wade's phone traveled to and remained at Yurdi's condo during the geofence at times when the clubs, when all the restaurants, when all the Porsche experiences are not even open for business. Are they open at 3 in the morning? Nor does the state choose to inform the court that this is the same data that they routinely rely upon for their convictions in their own prosecutions, and thus any suggestion that this data is unreliable is disingenuous at best. They also try to equate this evidence to specific bad acts of conduct that was used to try to impeach Bradley. But this evidence is not the same character of evidence. It is not specific acts of conduct of Wade or DA Willis at all, right? So Bradley, they're saying he, assaulted two other people, employees and others. This is not that at all. This is just, spreadsheets. So just spreadsheets from AT&T that somebody analyzed. So the breadth of this cannot be overstated. Impeachment of Nathan by disproving facts that were testified to by a witness doesn't need to occur on cross-examination of the witness. If the witness testifies to a certain fact, and the opposing party may impeach that witness simply by calling another witness who offers contrary testimony about the fact at issue. Impeachment may also be achieved simply through the introduction of a photograph. In Kelly, another Georgia case from '98, that defendant testified he never walked around the house nude. No, never, ever, never, never, not once, never nude. The opposing party was then permitted to impeach the testimony. They just showed a nude photo of the dude in his house. So like, what about this time? He's like, oh yeah, forgot about that one time. And that was during the punitive damages phases of the trial and when the witness expressed remorse. The plaintiff was permitted to introduce a letter, another case. They were allowed to introduce a letter threatening litigation. And so the impeaching testimony may simply reveal that the witness's version of events is less likely to be true. The defendant was charged in this other case with aggravated assault with an intent to commit the ARG. He offered a hospital record of the victim that revealed she had cocaine in her system. The Court of Appeals held this impeaching evidence should have been admitted because the evidence supported the defendant's version that she was the aggressor. She was hopped up on cocaine like Hunter. In short, the impeachment cell phone evidence can be introduced simply by offering the records that demonstrated that they spent 2 nights together on dates that contradicted their version of events concerning the inception of their romantic relationship, and in contrast to their testimony that they never spent the night together at the condo. Now, the defense does not propose that the court compromise by simply admitting the records into evidence. No, the preferable method would be to allow our witness, Middlestat, to testify and to be subject to cross-examination by the state here. They say the evidence is also admissible as a relevant substantive evidence tending to show that there was a close interrelationship between Wade and Willis during a time that Willis was living at the condo. Remember, Wade was hired on November 1st, and they both told us under oath that no relationship started until 22. Now, the breadth of the Georgia law is also compatible with the basic philosophy of the evidence code, which codifies the definition of relevance as defined, saying relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence more or less probable than it would be without the evidence. So if any bit of evidence helps you decide even a little bit, it's relevant. Given the testimony of Wade and Willis, they testified that they never spent the night together in the condo. The evidence, the actual record evidence is not just an opinion or speculation. It proves that while talking on the phone with Willis, Wade drove from near his house to a location near her condo, if not exactly to her condo, at midnight, where he then remained there for 5 hours, not once, but twice in 2 months. That qualifies as relevant evidence, if not presumptive proof of the fact that they did spend the night together on those 2 occasions at the condo. And to be clear, presumptive proof is not required as a precondition to the introduction of this evidence to prove a point. Evidence is relevant under the law when it's low, okay? When it tends to make a fact that is of consequences more likely. Very liberal. It's a very low standard. A lot of stuff comes in. So the cell phone records that show that they were talking on the phone and then ended up at a location near or at her condo for 5 hours makes more than just one fact more likely than not. 1, they spent the night together on those 2 occasions, and 2, their romance began before Wade was hired. So that's a lie. And one more fact, also more likely true than not, neither of them testified truthfully at the hearing on February 15th. Clearly true. And so therefore, President Trump respectfully requests that the court rule that the cell phone evidence of Nathan Wade is admissible, permit the defense to call Middlestat as a witness to testify about this, and the use of the software called CellHawk as reflected in the affidavit, and to admit all of the other exhibits attached as evidence in this case. Signed by Steve Sadow and Jennifer Little. Shout outs to both of them for doing some awesome work here and served back on the government. Fani is not happy about this. So they've got some very good case law. Now, even just comparing and contrasting these 2 filings, what do we see here? Did you see any bold, capitalized, underlined, screeching rants from Steve Sadow? No, you didn't. You know what else you saw here? Some case law. We actually had some case law here. We have Goodwin versus State of Georgia. We got Bowen versus Bowen. We got Fowler's in here. We got Kelly versus State, Martin versus State. Bunch of Georgia statutes are being cited. A lot of evidence to support their claims. What we saw in the prior filing was not much of that. We saw very little case law throughout this entire thing. They referenced Daubert, which they didn't even use that appropriately. They're trying to shove this guy in as an expert, but he's not. So they use some case law that applies to Daubert, but it's the wrong area of the law. So very good filing from Trump and his defense trying to get these records admitted in. And I'm very hopeful the judge ultimately allows it. I think it should be allowed. The judge is facing a situation where the county attorney and the special prosecutor lied directly in his courtroom and doubled down on it multiple times. And the cell phone evidence is just evidence that they can explain. If they think that it is so erroneous and so problematic, they can explain that. Come out and explain what they were doing, whatever legal brief they were working on, and why that didn't match up with their testimony. Nobody's going to believe it. Now, they are coming back here for summation arguments on Friday, my friends. And so we're going to be covering that live. Make sure you are subscribed. We are not going to be missing that, and it's going to be juicy. But there will be some more litigation that happens, right? The judge is probably going to issue an order on this, so we know whether or not they're going to be reopening some evidence or whether Middlestat will have the opportunity to testify on Friday. We also know that there was an interesting event today because Terrence Bradley was apparently meeting with the judge today, Judge McAfee, to talk about the difference between bro talk and pro talk and whether Terrence Bradley can be another witness who's going to provide even more evidence that Fani and Nathan lied. Remember, Robin Yurdy, who was a former employee of Fani Willis, said that their relationship started way before they said it did in 2022. Terrence Bradley may be able to come out and support that claim as well because he, although was Nathan Wade's lawyer, he was also his friend for a long period of time, and so he might have some bro talk that is not pro talk, that is protected by attorney-client privilege, and if he can come out and explain that to the judge, now we've got just a whole boatload of evidence. We've got Robin Yurdy, we've got cell phone records, we'll have Terrence Bradley, and we'll have all of their other inconsistencies and lies that they told us on the stand, and it will be a damning case for them, one that I think that Judge McAfee will not be able to overcome. Here is what 11 Alive says. Terrence Bradley was there. She was outside the courtroom today. Here's what it sounded like.
Aisha, Judge Scott McAfee, he will meet behind closed doors with Special Prosecutor Nathan Wade's former attorney, Terrence Bradley. Now, this will happen behind closed doors, so we won't see the firing and compelling testimony that we saw at the initial hearing. And this is all as defense attorneys are questioning when Nathan Wade and Fani Willis started dating. Special Prosecutor Nathan Wade's former attorney, Terrence Bradley, will meet privately with Judge McAfee as defendants in the election interference case continue their quest to get DA Fani Willis and Wade disqualified for having an alleged relationship before Wade's appointment to the case. Attorneys for the defense believe Bradley can prove Willis and Wade's romantic relationship began earlier than what Wade and Willis testified. Bradley took the stand during the initial hearing but invoked attorney-client privilege and said he he cannot speak to Wade's relationship without putting his law license at risk.
Advised by the bar that Rule 1.6 of confidentiality applies and that I cannot reveal anything that I saw or learned.
Wade attempted to block additional questioning, arguing private questioning by Judge McAfee may unlawfully compel Bradley to break attorney-client privilege. The timeline of Wade and Willis's relationship has been the main point of focus for defense attorneys.
Because they lied.
While Wade and Willis insist they started dating in 2022, lawyers representing former President Donald Trump claim new cell phone evidence can prove otherwise. Attorneys say those records reveal at least 35 occasions in 2021 when Wade's phone connected to cell phone towers near Willis's condo in Hapeville for extended periods of time. In court, Wade says any cell phone records suggesting he was in Hapeville would be wrong and that his visits to Willis's condo were for business. And the DA's office says the records do not prove anything relevant and should not be considered as evidence. Now the judge must rule whether those cell phone records can be used as evidence in disqualification proceedings. Meanwhile, the next date that we're looking towards is March 1st, and that's when Judge Scott McAfee has set that date for disqualification arguments.
All right, and so we're going to obviously be here covering that, my friends. So very interesting response from Fani. Caps lock, bold, underline, screaming. The poor guy doing the typing on there, getting abused in her office. Make it bigger, make it more aggressive. Fani's very upset about this. And so we're going to be here covering this, my friends. There's going to be a lot to get to as this unfolds. I imagine we're going to see some new filings, probably some more motions drop between now and the hearing on Friday. We're going to be here covering it live. So we'd love to have you join us. Thank you for hitting that like button. Thank you for subscribing. Thanks for bringing over someone to come and join us here on the show. We go live 5 days a week here, watching the Watchers live, and we're very grateful to have you here and with us. We also have some great links down in the description below. If you want any of the PDFs, go to robertgovea.com. We post all of the show segments up there along with the PDF so you can download it. We have our newsletters there. We have our merch shop is over there, and we'd love for you to check it out. We also have some events coming up at watcherlodge.com, free events. We have Political Zen Wellness coming up, and it's going to be amazing. So come and join us, all free, watcherlodge.com, and we'll look forward to seeing you back here, my friends, on this case and all the other Trump prosecutions right back here on the next one.